The next question that I have, I agree, Steve, about, there was testimony from Ms. Diddy who suggested that Section 14 be removed, but add in that the medical emergency applies to all situations. But she didn't specifically say to put it in Section 2. I did hear Mr. Hendrickson say that.
Correct.
But I heard her say in the bill, this
Sure.
bill.
It
So
could-
that means it may be in multiple parts of the
It could be
bill.
put in other places. My point is, this bill was tightly drafted so we didn't have every abortion battle in the world on the House floor, to be quite honest about it. So it would be germane to have an amendment that said the exception, which applies to life of the mother, major bodily functions, reasonable medical judgment. That's fine as far as that goes. But the problem with it is it doesn't address this concern about furnishing, accomplices, prosecution of the women. And if somebody asks me about that, I'll explain about that issue as well. And if the Fifth Circuit ultimately holds that 4512 is still alive, then you're going to have a potential conflict between that language in one code and language that's alive in the other code. And this is the thing that we've been wrestling with is, how do you reconcile that? If the courts rule it a conflict, the later passed law would govern. If they say we're required by the rules of statutory construction to harmonize these things, and it gets harmonized, then physicians in hospitals have had no protection during the rest of that time, and 4512 doesn't have the substantial bodily impairment component to it.
She said that if you remove that Section 14 and add that medical exception language, it would apply even if they claimed that the 45 or 1925 ban was revived.
Only so far as the life of the mother,
Yes.
And it would cover major bodily functions when the 4512 does not. So the question is that a conflict, or can that be harmonized? And are you going to rely on the Fifth Circuit Court of Appeals to treat that? These are matters of statutory construction, by the way. This is not federal law here.
Right.
In McCorvey, the court construed earlier passed statutes as being in conflict with later passed statutes, and so the earlier ones were repealed by implication. Since that time, this legislature has passed laws that are certainly arguably, they're certainly the same policy as the old law, and so the court could come back and say, well, the whole fundamental underpinning of that is gone. Now, how they're going to respond to that, do I know? I don't. But what I do know is for 12 to 18 months, until at least the Fifth Circuit deals with that, there's going to be a hole in this statute that, as far as 4512 goes, doesn't answer those questions. If you can somehow shoehorn the life of the mother and the major bodily function deal, maybe that addresses part of that. I don't know. Then I know if it's alive, then you may have a conflict between that and this other. And by the way, I'm just doing what I wrote down. I haven't seen this language. I haven't seen where it be placed, so I don't want to treat the witness unfairly.
Oh, right. So what I wrote down, so she was saying remove reference to 4512.6 because she feels,
I understand,
based on what that it would revive all the whole thing, even though it says that it's impliedly, it's not in effect.
Yes, ma'am.
Because of that case law. But she said if you add the medical emergency exception in this bill applies to all Texas abortion statute, she feels that those exceptions under the medical emergency would apply to even those under 4512. So the exception would still provide protection.
I understand.
And you're saying,
and if the Fifth Circuit, yes, ma'am. I'm just making an additional point here.
Okay.
If 4512 is determined to be alive, see the lawsuit was brought by folks who are funding people to travel out of state for care. Okay, and that's where the furnishing the means of concerns comes from.
okay.
So that's not going to have this suggested amendment's not going to have any bearing on that issue whatsoever. It would be the, what the Fifth Circuit ultimately decides on that. And I'm saying Fifth Circuit, this could go to the U.S. United States Court of Appeals. Elizabeth could tell you better about what would be the appellate trajectory of that.
I'm happy to do that in response to a question too. Just, you can finish up.
Okay, sure.